Outdated processes and systems waste valuable billable hours. LawPay's trusted, industry-leading payment features get you paid 33% more and 39% faster. Maximize efficiency and profitability with payment features like automated billing, flexible payment options, and next-day payments. Do more of what you're meant to do, with a partner committed to your greatness. Sign up by July 31st and LawPay will cover up to $150 in processing fees incurred through July. Learn more by visiting lawpay.com/dcbar. Tired of spending hours of your day scheduling appointments and chasing down payments? With MyCase, you can reclaim 3+ billable hours daily so that you can spend time on what matters most, serving clients, optimizing team efficiency, and maximizing your law firm's profits. Sign up for MyCase Advanced by July 31st and enjoy 35% off your annual subscription fee. Terms and conditions apply. Learn more at mycase.com/dcbar.
Welcome to Brief Encounters. This is our third episode of the Securities Regulation and Enforcement series. My name is A.Valerie Mirko. I'm a partner at Armstrong, Teasdale, and I'm also the leader of the firm's Securities Regulation and Litigation practice. With me is William Nelson, an Associate General Counsel at the Investment Advisor Association, as well as our very first guest on our podcast series.
Yeah, Valerie, and thank you again for that introduction. We are so excited. Our first guest on the podcast is Deborah Meshulam. She's currently one of the leaders of DLA Piper's Securities Enforcement practice. Prior to that, she actually served for 7 years as the Assistant Chief Litigation Counsel for the Securities and Exchange Commission's Division of Enforcement, and as lead trial counsel, she prosecuted several securities enforcement cases, including insider trading cases. So we are so happy and thankful to have you, Deborah.
Well, I'm very excited to be here and to talk with you about some of the recent securities issues that have come up, particularly in the insider trading arena.
So happy you're here, Deborah. And yes, today's episode is going to focus on recent developments in insider trading. But as you know, this podcast series is really predicated on looking at any securities developments through the lens of Dodd-Frank, first and foremost, and really taking a bit of a retrospective look as we look at current developments.
Well, I'm happy to cast insider trading a little bit in the development of Dodd-Frank and how that statute has evolved over time. When Dodd-Frank first was passed back in 2010, I recall in my practice, the focus wasn't so much on insider trading as it was on advising clients with respect to the new whistleblower provisions and the rules that were coming out and what it meant with respect to their business and their agreements in terms of the anti-retaliation provisions. And I'll note that the Office of Investor Advocate was also established, in both of the Whistleblower Office and the Office of Investor Advocate both became conduits for potential SEC enforcement cases. And there were a number of other rules that were really in the forefront. I recall in particular working with clients on a comment letter pertaining to the conflict mineral rule proposal. And there was also a lot of focus, as I'm sure you both recall, on the identity theft red flag rules, which came out, a few years after Dodd-Frank was enacted. But in mid-2014, the SEC had faced some challenges in Article 3 courts with certain types of insider trading cases. And the then director of the Division of Enforcement commented that under Dodd-Frank, the SEC actually had power to bring insider trading cases in the SEC's administrative courts as opposed to Article 3 courts. And in fact, that was something the SEC would do in appropriate cases. And the division director was speaking of what was Section 929P of Dodd-Frank, which gave the SEC power to impose civil penalties against any person in its administrative proceedings, as opposed to just those who were associated with registered entities such as broker-dealers, investment advisors, and so forth. And in fact, within a few months of having made that statement, the SEC did, for the first time that I'm aware, bring insider trading cases administratively against two individuals who were not connected with broker dealers or hedge funds or investment funds, but rather two individuals who allegedly engaged in insider trading. One of them learned from his roommate some information about a public company and tipped the second individual about that information, and that second individual traded. And those two individuals, Philip Seismic and Jordan Piexto, were both sued administratively by the SEC instead of the case being brought in an Article 3 court. And that was a very interesting development and one that defense lawyers paid attention to. But at the same time as that case was initiated in September of 2014, you had another trend that was developing that was going to have very significant impact on the SEC. And it related to a series of claims which found their way to the Supreme Court, all of those claims challenging various aspects of the SEC's administrative process, starting with the Lucia case that challenged the constitutionality of the appointment of the SEC's administrative law judges. That was a case that the SEC had initiated in 2012 that the Supreme Court ultimately decided. And then you also had the Jarchese case, which is currently pending in front of the Supreme Court, but which was first initiated in 2013, that challenged the limits of the power of administrative law judges to award civil penalties, the loss of the right to a jury trial, and a number of other constitutional claims. And you also had the Cochran case, which challenged court decisions that said if you wanted to raise constitutional claims, you still had to go through the SEC administrative process and have those claims raised in that process instead of an Article 3 court in the first instance. So all of this was percolating in lower courts, in the SEC's administrative courts and in lower courts, just as the SEC, for the first time, started to bring insider trading cases in the administrative process. The result was a lot of uncertainty. And from what I've seen in a very informal review, the SEC has chosen not to bring contested or any insider trading cases in the administrative forum as Dodd-Frank permits it to do, but instead has continued to pursue those cases in Article 3 courts. And most recently, one of what I would view the most significant recent cases, SEC v. Panuwat, has played out at the district court level with a trial and the SEC's success in what has been described as a novel theory of insider trading known as shadow trading.
So before we jump further into shadow trading and SEC v. Panuwat, is it fair to say that ultimately, with the benefit of hindsight, Dodd-Frank had a very small impact on how the SEC brings insider trading cases, and the SEC kind of continued on its usual path in terms of its approach to insider trading?
I agree with that. And it remains to be seen where things might end up until Jarchese is decided as to whether the potential that Dodd-Frank presented in Section 929P will ever be realized.
Yeah, and Deborah, getting into Panuwat, one of the questions I have is that, we've had these different theories of insider trading previously, but how did the SEC, based on your experience, kind of arrive at this new novel theory of insider trading?
The SEC would say that this is really just a misappropriation case. And on a certain level, that's correct, because the fundamental argument is that the defendant, Mr. Panuwat, misappropriated information that belonged to his employer, which he then used to trade to his benefit and in violation of the insider trading laws. But what's really different in this case is it's the expansion of the concept of what is material to whom. And this case involved an acquisition. And in a typical case, and in all the cases that preceded Panuwat, the information, the material non-public information that would be at issue in this type of insider trading case would be information related to the company being acquired or information related to the company that was making the acquisition. In Panuwat, for the first time, you had the information relate to a third party, a third company that was neither the acquirer nor the target or the company being acquired, but rather a company that was outside of the transaction. And the concept that emerged from this case through the motion to dismiss and motion for summary judgment, and now, of course, the verdict, at least so far, is a recognition by a district court that information can be material to more than one company, and material non-public information doesn't need to come from the issuer to whom the information relates for it to actually be material. I want to caveat this that no one knows where this case will go on appeal, but when you look at what the judge decided and you go back to read the text of the statute and the rule, it speaks very broadly of what the violation is. And you think about it, purchase or sale of any security based on material non-public information regarding that security or that issuer or an issuer in breach of a duty to the source. And so that's the purchase or sale of any security. And the court in the motion to dismiss, that when allowing the case to go forward, focused on the concept of any security and the fact that these statutes don't define everything that is insider trading. They just give examples. They use the word including, and the concept of insider trading capturing a wide net of activity. And so what you see in Panuwat is a case with facts that really lent themselves to the casting of the wide net to expand what everybody previously had viewed as material non-public information. It's a fascinating case because of that, and as you think through the potential breadth of what this could mean. But the facts here were very compelling, I think, for the SEC and to try to make this theory stick, and they were successful.
Yeah, so Deborah, we'd love to hear about some of these interesting facts in the Panuwat case, because it's interesting, one of the points you made previously, that the SEC did consider this just kind of, the logical extension of a misappropriation case, while, I know many others did describe it as novel. But yeah, I'd love to hear you kind of talk about and go through some of the facts of the case and how the court ended up ultimately viewing that.
Absolutely. I will say, ultimately, it was how the jury viewed these facts, because the case went to trial and a jury found that the SEC had proved its case by a preponderance of the evidence, so slightly more than 50%. But here, the facts are very important. First, you're dealing with a merger and an acquisition transaction, which is one of the most important types of transactions for a company. And it was the type of transaction that was at the heart of Basic v. Levinson, which is one of the major Supreme Court decisions reciting the relevant standards with respect to materiality. And Mr. Panuwat was employed by the potential target or the company that was going to be acquired. And he wasn't just any employee at the company. He was someone who was actually involved in Medivision's search for a buyer. He was involved in the analysis of what the impact of an eventual sale would be. And as a result of his role, he received confidential information about the sales process that was not available to the market. The market generally knew there was a sales process. It maybe had some general sense of timing, but the market did not know what the proposed prices were, didn't know the timing of the bids. And this is all information to which Mr. Panuwat was privy. And he ultimately received an email that contained the proposed price, identified using a code name that he understood which company was offering that price and that company's desire to finish the deal over the weekend. So he had the timing information, specific timing information. And then 7 minutes later, he bought call options in the third company. And call options mean that he was placing a bet that the stock price of the third company, Insight, was going to rise. And as the SEC laid it out, Insight wasn't a random company that Mr. Panuwat had plucked from the air. Rather, Insight was a company that had come up in the course of the discussions and the analysis that was being done internally about the acquisition. The Medivision CFO, for example, had identified Insight as one of the few other mid-cap oncology assets that was still in the market, together with Medivision. Mr. Panuwat had also discussed Insight with his employer's financial advisor. And so the name of this third-party company, Insight, had been included in various decks and was tied to the transaction that was being explored confidentially within Mr. Panuwat's employer. And ultimately, the question was whether the fact that Mr. Panuwat's employer was going to be acquired by a third party could be material to a company that was unrelated to the transaction. And on the motion to dismiss, the court concluded that that was possible. That was based on the language of the statute. The case could go forward. On the summary judgment, the court said that there were triable issues of fact on those issues. And the case went to the jury, and the jury concluded that, in fact, the information that Mr. Panuwat had regarding the price and the timing of his employer, Medivision's acquisition by another company, was material to Insight because the two companies were related in the market, something that the SEC also had to prove. And in terms of the duty analysis, Medivision's insider trading policy said that its employees should not trade while in possession of material non-public information about any company or something to that effect. And then it had a list including customers, suppliers, and so forth. But the court found that because the language of the insider trading policy referred to the securities of any company, it could encompass Insight. And so you had the breach of duty to the source of the information, in this case, Insight, Mr. Panuwat's employer. And the elements were met, and there were tribal issues of fact for the jury to decide.
Deborah, I don't want to say bad facts make bad law, but hearing you describe the facts of Panuwat in detail, it seems like the SEC staff had a good set of facts to make its arguments, particularly in a jury trial context.
I agree with that. If you think about another set of facts, I don't know if they would have been as strong. So you can imagine a scenario where a company on a regular basis circulates an email to a group of its employees that says, here's how we're doing compared to our peers. And all it does is it lists the peers, which is often publicly available, and it lists, the company's stock price, and then it lists peers 1 through 10, and it has their stock prices. And I receive that email on a regular basis that just sort of lists all this publicly available information. And because I understand the market, I'm able to extract from whatever trend I see of, how my company's price is doing compared to peers 1 through 10, and I make some securities trades. And my company has graciously put together all the public information for me in a single spreadsheet, so I don't have to go do it myself. And maybe I never would have done it, but I have it in front of me. And this has somehow informed the decision that I make to trade in, peer company 3's securities. Is that now going to be fodder for a potential insider trading case? I don't find those facts as compelling if there's nothing else going on. In Panuwat, you have a merger and acquisition, and you have an individual who's at the heart of the transaction receiving information about the price at which that transaction is going to occur and the timing of the transaction, and having an understanding of the relationship in the marketplace between the two companies, armed with that information, makes the trades. To me, that's a more compelling case than the example I gave, where I'm just on a regular basis, nothing else, getting a list of publicly available stock prices of my employer's peer companies. And I think a crucial fact is also that Mr. Panuwat made his trade 7 minutes after he received the email that talked about the price and the timing of the transaction.
Yeah, no, that definitely makes a lot of sense. But yeah, I think there is that worry that, just like Valerie said, kind of bad facts make bad law. But, one other quick question I would love to get your opinion on is that, looking back at the trial, I read that the jury actually came back in about 2 hours. And that seemed like a pretty, complex case to go through. So I'm just curious if you read anything to that. Maybe the jury thought this was a pretty straightforward case to them, but I'm just curious on your takeaways of that.
I take away that the jury thought it was a straightforward case, as you said. If I'm sitting on a jury, you have an individual who gets some key information about a major transaction, who understands how that information is going to be received in the market. And no one, I as a juror, a reasonable investor, I don't have that information. And 7 minutes after he got that information, he placed a bet that the stock price of this third company would go up. He had a market advantage that I didn't have as the reasonable investor, and he got it by using information that belonged to his employer. So you could distill it into something very simple for a jury to understand. And what I have read about the trial suggests that the SEC was able to demonstrate that the price of Medivation stock and Insight stock was in fact correlated, and that knowing that this acquisition was going to happen and was likely to positively impact Medivation stock price enabled Mr. Panuwat to be reasonably certain that Insight stock price would also be favorably impacted. And so a jury could look at that and say, he really did have an inside information that he used, and he wasn't supposed to use it because his company had a policy that said he couldn't use that sort of information, and he breached that policy. And so the SEC has made its case.
I think that's exactly right. And William, I read the same thing about the 2-hour jury deliberation, but I was also very struck, and especially now that, Deborah, you've walked us through the facts, they really come to life in an incredibly accessible way.
It's a case that has broad implications in couple of different ways. First, how companies structure their insider trading policies and how they train their employees with respect to insider trading. And second, how other market participants who learn information and have expertise about the market in a particular area, how they have to think about the information they have and whether they might be running afoul of some insider trading prohibition. This is what I anticipate will just be the first of these types of cases as the SEC continues to aggressively pursue insider trading.
Especially because the SEC has a history of robust pursuit against insider trading. And this is such a victory for the SEC that they will want to leverage that very quickly.
Absolutely. The SEC has always been focused on trying to avoid illegal disparities in market information in terms of somebody has information and trades on it, and they aren't allowed to trade on that information. The market doesn't require parity of information. Courts have recognized that over and over again. But our insider trading laws prohibit illegal unfair advantages, and the SEC is very focused on eliminating those types of illegal unfair advantages.
So, Deborah, being in DC, a lot of things we think about are through the political lens. So, just from your experience looking at these insider trading cases, do you think we will see any kind of position change in the SEC if, depending on how the election ends up, if there is a change in leadership?
Regarding insider trading, I don't anticipate any change at all. Insider trading has been a core focus of the SEC, regardless of which administration holds office.
Yeah, I think that's really helpful for our audience because I know that sometimes when the political winds change, even an independent agency like the SEC. One other quick question I had, or hopefully it's quick, is that, one of the things we pointed out in previous podcasts related to the fiduciary duty is it's really, there's no statutory definition. The law has been made by the courts. So do you think that provides the SEC with the opportunity to kind of, keep pushing the boundary on these types of cases?
It does, but I also want to draw everybody's attention to the fact that there is a rule 10b-5-2 under the Exchange Act, which does provide a description of duties of trust or confidence, and it gives 3 categories. And these are not exclusive categories. They're not the only categories, but there are categories that are listed there. And my expectation is that the SEC is going to continue to push with respect to this concept of duty and what is a duty of trust or confidence that can be breached in a misappropriation case. In the Panuwat case, it was information that belonged to his employer that was misappropriated from his employer, and the SEC was able to prove that he used that information in breach of a duty that he owed to his employer. And that's fairly straightforward at a certain level. It was, in this case, I think more a question of what the information actually was and how it applied to a third company that was not connected to the transaction.
And yet also the very fast timing by which Mr. Panuwat essentially made a bet through his trading on that third company. I think you mentioned it was 7 minutes.
Right. And that is a classic indicator of materiality in this, or a factor in terms of how the person who has the information reacts to it can indicate that it's material. In the same way that how the market reacts once the information becomes known is an indicator of materiality. So there are a variety of ways to show that information is material. If he had received the information and traded 2 years later, and that was the only information, it would be very hard to show that it was material. But this was 7 minutes, not 2 years, not even 20 minutes, which would still be very quick. So the timing of his purchases certainly was an important factor.
So as novel as shadow trading is in terms of a case theory, there are some classic core elements to the facts in SEC v. Panuwat as well.
Yes, I agree.
Deborah, is there anything else that you wanted to discuss on SEC v. Panuwat before we wrap up?
No, beyond the fact that it's a really interesting case that is worth attention, and it will be also interesting to see what the SEC may do next in this particular arena, armed with a decision from the court here that information can be material to more than one company, which makes sense when you think about it. But how broad is that net? So that's going to be very interesting, and it will be equally interesting to see, whether and how this plays out on appeal. I'd like to thank you both for having me here. This has been wonderful. Always enjoy talking about interesting developments at the SEC, and I look forward to hearing the remaining podcasts in this series.
Well, again, Deborah, thank you so much for coming on the podcast today. It's definitely been illuminating, really walking us through Panuwat, looking at the facts of the case, I think is really helpful for the audience. And yeah, I definitely, we'll definitely see where this goes from here. If there's appeal, we definitely may have to have you back on the podcast.
This episode of Brief Encounters was brought to you in part by our sponsors LawPay and MyCase. Find out how these solutions can work for you by visiting lawpay.com and mycase.com. For more information, check out the description of this episode.